Today's topic is about Sharia risk management. I think in the previous past lectures, I have already introduced to you the various type of risks exposed or available or exist in the Islamic banking and finance. Okay, and one of the type of risk is the Sharia risk. Okay, and now we want to know how is this Sharia. I mean, we want to know more about what is Sharia risk. Okay, I think I've already explained to you that basically one of the risks, related to Sharia risk is the non-compliant risk. Okay, so non-compliant risk basically it means that if a product or a services offered by an Islamic bank become non-compliant, then at that point of time the bank will be exposed to what we call the non-Sharia compliant risk. Okay, so we want to know more about Sharia risk and how the what we call this Sharia risk is being managed. And I've also explained to you that Islamic Bank, one of the, the core of Islamic Bank, or we call it the bedrock, the foundation of Islamic Bank is about complying with the Sharia. So the issue of Sharia risk must be we call this look at or handle or managed by Islamic Bank. Apa orang kata, they have to be very kena, tak boleh lah, they have to really what you call this, they have to really manage, or they have to really aware of the Sharia risk, because complying with Sharia is it's Islamic banking all about. An institution established within the ambit of Sharia, Islamic banks are expected to ensure that their aims, activities, operation and management adhere to the Sharia principles and values. As Islamic bank is about complying with the Sharia, so Islamic bank must ensure that all of their offering, all of their services, all of their product, operation, okay, and management activities, how they conduct business must follow the principle of Sharia and values. And the failure to comply with the Sharia, what is required by the Sharia, will expose Islamic financial institution to the non-Sharia compliance risk. And it is also a fiduciary duty for Islamic bank to manage risk properly, to make sure that if there is incident of non-compliance, they have to what you call this deal with it immediately. Okay, in order to effectively manage the risk vulnerability of the Islamic banking, proper measures for risk management have been put in place in different frameworks that are either domestic or international based. So to effectively manage the risk in Islamic bank, there must be a framework. I think last lecture I have shared with you the guiding principle or the framework or the standard that Islamic bank must follow framework like issued by Basel III, issued by IFSB, and enforced by the Bank Negara Malaysia. Okay, so those are the document that all Islamic bank must understand, must follow all the requirement. Okay, those like the Basel III, IFSB, Bank Negara regulation, and all those are I mean document for managing the all type of risk. Okay, so the management of all type of risk that a bank, being whether it's Islamic or conventional, must have in place on how they want to manage the risk. Okay, but in particularly for Sharia risk, okay, particularly for Sharia risk, there are separate or additional so-called additional framework or standard or policy that Islamic bank must follow. And one of them, I mean, in the context of Malaysia, we have Sharia Governance Framework or SGF 2010. Okay, and also we have IFSB principles and Islamic Financial Services Act 2013. Okay, all these three framework or act or principle or document deal with the Sharia risk management. And I think you must also aware that this SGF now has, I mean, the Bank Negara Malaysia has already issued Sharia governance policy replacing this SGF. So the SGP or Sharia governance policy, which I will also cover later, is the document that Islamic bank must adhere to. Okay, so the issue of non-Sharia compliant, or we call it Sharia non-compliant. Okay, or if you talk with a banker, they call it SNC, which stands for Sharia non-compliant. Okay, and of course, the event that lead to Sharia non-compliant, they call it Sharia non-compliant event. Okay, Sharia non-compliant risk is a subset of operational risk. Remember, I have also introduced to you one of the type of risk that exposed to banking industry, whether Islamic or conventional, is operational risk. So basically, in the context of Islamic bank, Sharia non-compliant risk is basically a subset or part of operational risk. It has to do with the operational risk. Operational risk that the Islamic bank exposed to can later turn into the Sharia non-compliant risk. According to, and we want to know what is the definition of Sharia risk, and according to Bals, okay, according to Bals, he defined Sharia risk as the chance that an Islamic financial transaction is challenged on the ground that it does not comply with Islamic law. Okay, so in other words, um, any product, loan, financing product or services offered by Islamic bank, if there is a loophole or there is a weakness whereby the customer or anybody can bring the issue to the court and they want to challenge that this product is not comply with the Sharia, and this happened before. I think more than 5 years back. It's about the BBA, Bank Bitaman Ajil, where a customer bring the issue to the court. So that has basically orang kata menggegarkan industri perbankan, because mahkamah, in that case mahkamah or the judge is of course is the apa this Mahkamah Civil, okay, the civil court judge ruled that the product, I don't remember which bank, I think Bank Islam, which product, that product is null and void. What you call this is not comply with the Sharia. So kalau that ruling what call this remain, nanti akan ada lagi customer lain akan bawa kes ke mahkamah to challenge that the product is not tak patuh syariah. So what happen if the judge rule that the court the product is tak patuh syariah? Of course the customer don't have to pay the what call it, the installment. So of course it will affect the industry very badly. Okay, so after that case, I think Bank Negara has amended the act. I think Bank Negara's Act or IFSA. I think IFSA and also Bank Negara's Act, and the government or Bank Negara has included a clause saying that a civil court in what call this ruling, or if there is a case regarding Islamic bank, the judge at the civil court must refer to the Sharia Advisory Council of Bank Negara to avoid all these issues. Okay. According to Karim Jinena, he defined Sharia risk as the risk of financial losses that IFI may experience, okay, as a result of a non-compliant with the Sharia precept in activities as ascertained by the Sharia Supervisory Board or pertinent authority in the relevant jurisdiction. Because if a product suddenly or later on declared as non-Sharia, I mean does not comply with the Sharia, of course, the income that the bank gain from that customer or that product will apa ni, can they call it is a tainted income, and the bank cannot consider that income as the profit for the bank. Of course, it will affect the bank's bottom line or the bank's profit due to the we call it Sharia non-compliance event. When I say Sharia non-compliant event, meaning to say there are cases or customer or product that initially when it was launched, it is complied with the Sharia, but due to operational matters, later on I will go into detail. Due to the operational matters, the product it's not that product. Maybe that particular customer become Sharia non-compliant.